Fine with that, Your Honor.
Yeah, that's fine.
The facts are the same, you know, you seem to be free.
We're fine with that.
All right, so 20 minutes per side. If it needs to go a little long based on questions, I'll let you know that. We'll adjust.
Thank you, Your Honor. Leah Muiro on behalf of the appellants, Araceli Perez and Joaquin Perez. I'd like to reserve 5 minutes for rebuttal.
Very good.
May it please the court. This is a quintessential negligence case that juries are tasked day in and day out with deciding. And the question here is whether the court, in not acknowledging the testimony from the plaintiff, should have reviewed the photographs and make a decision based on that photograph alone that this was, one, an open and obvious condition, and two, that the defendant properties maintain the property in a reasonably safe condition. It is our position that the trial court should not have done that, and that this court should reverse that finding.
Well, as I read the hearing transcript, it seemed like we conceded that the photographs may or may not accurately depict the condition of what the strength, whatever it is, and actually flat.
That is correct, Your Honor. During his
Okay,
finding,
so then we have testimony from Southern Gray, who was out there twice a month, who would, and he did testify that rain would cause the sides to become steep. It's his job to smooth them down so that there was like a gradual, say, drop off, because the drop off seems to be sudden, but it's a gradual slope, correct?
that is what he was tasked.
Okay, so we don't have photographs that accurately depict it, but we have testimony that seems to be undisputed that he's out there at least twice a month, if not on call, to do that.
Yes, Your Honor, but
And it's at least 16 feet wide.
that is correct, Your Honor, but the photographs were taken just a few hours after the fall. So while they did not correctly depict the color of it, but they did correctly depict the grade of what the slope looked like and what the ditch looked like. And the plaintiff testified, or Mrs. Perez testified, that the ditch was such that she was standing on the edge on the side, the sand slipped, and that's what caused her to fall into it, and demonstrating that it was sufficiently steep for that to occur. And so this was not in the condition as Mr. Clipper testified to, that whenever he would go out, he would use his two angled blades to create a long, gradual narrowing down to the bottom part to allow this area to drain. So, Your Honor, why I think your point is that while the court did say that he was disregarding the photos, or even without the photos, that this would be open and obvious, it is in direct contrast to the testimony of the plaintiff, who said in her deposition that she could not see the trench at the time of the accident because of the fact that it was the same color as the sand around it. And so in order to reach the conclusion that the court did, he had to disregard that testimony about the nature of what the sand looked like at the time of the incident. And there's a lot of back and forth in the briefs, Your Honor, about the summary judgment standard, but even under the summary judgment standard that applies here, as this court articulated in Lassiter, that it's improper for the court to either consider the weight of conflicting evidence, the credibility of witnesses, and ruling on a motion for summary judgment, which the court had to do here. The court had to disregard the testimony of the appellant that the man-made ditch blended into the surrounding area. He had to disregard that the ditch had sufficiently weak sides at the time that she was standing near it for it to give way and for her to fall into it. And in so doing, the only evidence that he had to rely on was the photograph, because there was no other beachgoer that came forward that said this thing was clearly visible at the time of the accident or anything of that nature. And so really the only testimony on this point, Your Honors, was that of Mrs. Perez.
But wasn't there testimony that there was no knowledge of anyone ever falling in this swale before? Yeah, so, and that being the case, you know, Brookie versus Winn-Dixie case, you heard me cite to in the earlier case, it's kind of applies here too, where the condition is so open and obvious, it's not inherently dangerous. There's no duty, and where the condition may be dangerous, but it's so open and obvious that an invitee may be reasonably expected to discover them and protect themselves. So we have that standard here. We have no ever proof that anyone's ever tripped on this before. Doesn't that make this pretty hard for you to make this argument?
Well, Your Honor, the same would be true of the Green case that we cited too in our brief, where a woman was traversing through a parking lot and she fell in a small hole that was in the parking lot that she claimed was similar in nature.
A small hole in a parking lot is not the same as a gradual swale on a beach.
I agree, Your Honor, that there is some differences in the factual makeup of the hole itself, but there's a first time for everything on these situations. And in this case, it is clear that the defendant had notice of the ditch. They were the ones who requested that Southern Grade come out and actually perform the duties that it had, because over time, the ditch would change shape and become more steep. And so in this particular case, it is clear, Your Honor, that the defendant had the notice of the dangerous condition. And Mrs. Perez, in her testimony, clearly stated that she did not see it and did not have that same benefit.
Let me ask a couple of questions, though, about siesta in particular. Your client was a visitor of Sarasota Surf, correct?
That is correct, Your Honor.
And this swale is between Sarasota Surf and Siesta, correct?
That is correct, Your Honor.
Okay, I didn't notice any evidence that the plaintiff was ever an invitee of Siesta.
And Your Honor, the trial court on this particular aspect of the ruling assumed that she was an invitee for purposes of the analysis in this case. Because even though there's a question as to exactly where this occurred, it is clear that both properties had control of the ditch. And so under the analysis for the case law, it's whether the property owner or that who is in control of the property. And these two properties jointly controlled this ditch to create it into higher Southern Grade to continually maintain it.
So what would be the opportunity Siesta would have to warn your client, assuming that this was a dangerous condition? If your client's not an invitee, there's no evidence that your client was even on Siesta's property, how would they exercise this duty to warn, which you think they have?
Sure, Your Honor. Because this is on the property line between the two properties and they jointly created this hazardous condition, those two properties could have worked together to create signage for the visitors to that area to make sure that they would have seen the dangerous condition that existed on the beach. And so although Siesta says there's no opportunity for us to have put any signage or anything like that, Your Honor, it is clear that they controlled this area of the beach and that they very well could have put signs in that same area because they had the right to continuously maintain this particular ditch. And so while it is on the property line between the two properties, they jointly controlled and created this dangerous condition, and they could have put up signage. And that doesn't also, Your Honor, just because if Siesta Beach says that they didn't have the opportunity to put up signage, they also still had a duty to maintain it in a reasonably safe condition because they were jointly in control of that ditch. And so even if they assume for a moment didn't have the opportunity to put up signage, they could have ensured that the ditch did not devolve into the steep conditions in which Mrs. Perez got injured in, which is what Clifford, Mr. Clifford from Southern Grade says that whenever he would go out, he would certainly try to create much more of a sloped condition than what occurred and what was present on the day of the accident in question. Your Honor, I wanted to briefly address the defendant's various arguments on whether this was an open and obvious condition or whether this was a dangerous condition. Defendants rely on cases like Olson and Dunn, which are curb cases. And in particular, in those particular cases, the courts have found that curbs are so common and so ordinarily innocuous that they're so open and obvious that they're not a dangerous condition. Our case is very different from what those curb cases exist. Curbs exist throughout all of Florida. These particular ditches that are on Siesta Key, there is no evidence that they're all over Florida. And on the contrary, these are something that happens and occurs on Siesta Beach. And so it would not be something that this plaintiff and this appellant would have recognized that there was just going to be a ditch on the middle of the beach. And so we posit that these cases that they relied on, like Olson and Dunn, are very different than what we have here. In addition, the defendants talked about the slope not being something that they could be held accountable for under the water cases like Saga Bay. But this case is also very different from those. Those are cases that are falling under a very distinct set of law applying to water and what a swimmer can expect in terms of a gradual inflow or whether there would be a drop off in a lake. And it is a very distinct body of law that occurs in those cases, and that those cases are cited for. But the point, Your Honor, that I would really like to make here is that the defendant's brief, where they pick apart certain aspects of the ditch, they say, well, the steepness of it, the color of it, the fact that it's a uneven drop off, all of these different cases on these one issue would establish that this isn't a dangerous condition or it's open and obvious. But it's the fact of all of those things combined, Your Honor, which makes this a case that should have gone before the jury and not proper for summary judgment. You can't take single elements of a dangerous condition and say, well, we can't be held accountable for the slope. We can't be held accountable if it was the same color as the surrounding area. We can't be held accountable if it was like a curve. It's the combination of these things combined with the fact that it was on the beach. And Your Honor, in the Green case that I cited to previously, and I would like to read this just because I believe that it's an important aspect of that case, is that an owner could still have a duty even if there is an open and obvious condition. Such if they should have anticipated that or they should have suspected that it could have still caused harm. And in that particular case, what the environment was is that she was walking through a parking lot with her children. There was a unique building. And the trial court said, even if this was open and obvious, there are circumstances in which the owner or person in control of a property should still owe a duty to warn even of an open and obvious condition. And the court did not analyze that issue at all. Rather, the court just said, this condition is open and obvious, end of day. And so we believe that that is grounds for reversal in and of itself, that the court should have looked at the environment. The beachgoers are often going to be distracted. Beachgoers are going to be taking care of their great-grandchildren, as she was in this case. They're going to be looking at the ocean. They're going to be walking along the beach as people do day in and day out in South Florida. And so there are environmental conditions similar to what existed in Green in this case, that even if it was open and obvious, this question should have gone to the jury as to whether they should have had a duty even in that circumstance.
How long is this swale or trench or whatever we call it?
How long is it?
How long is it?
It goes from the back of the property down to the main water.
Testimony is that long? Because in the photograph, it obviously looks quite long.
It is quite long. I don't know in the exact feet. There wasn't testimony as from how far that is from the back of the property down to the main water line, but it does go all the way down the beach. And so it does run that entire area from the back of the property down to the water. And Your Honor, this case is also very similar to the Schramm case out of the 5th District Court of Appeal, which was decided just last year, where a gentleman was walking toward a hole. He knew of the hole, which Ms. Perez didn't know of in this case, and the side gave way. And what the court said in that case is that even though the hole was an open and obvious condition, the danger associated with the hole, the weakening of the sides, was not. And so there's a very similar issue here where Mrs. Perez testified that she was walking along. She had paused to start turning back. And while she was standing there for that brief moment, the side of the sand slipped and it made her feel like she was being sucked in. And it's very similar to the Schramm case in that regard, in which
But in Schramm, the plaintiff notified the defendant. The defendant didn't do a thing about it, so the plaintiff was going over to the hole to measure the dimensions in order to mark it off, and he fell in.
Certainly.
This isn't the case. So obviously, the trial judges are allowed to make a finding as to open and obvious. The question is, are they weighing the evidence? I mean, we're all people. And so I understand and I appreciate your argument about sand. It is a sand, well, it's the same color as the level sand. But there has to come a point in time where the trial judge, based on objectivity, can say, based on the evidence and view of the photographs, this is open and obvious. We have an error. This thing goes from the pool to the golf. Another photograph. All the way to the golf. Kids playing in it. Such Carol do that was improper.
Your Honor,
Well, just objectively reviewing.
Your Honor, I believe that he weighed the evidence. He looked at the photograph. He disregarded the testimony of the plaintiff to say that the photograph didn't accurately depict what it looked like to her at the time because it was all uniform in color. And in order to reach his conclusion that it was open and obvious, I think he had to disregard her testimony, which I believe goes beyond objectivity and it goes into the purview of the jury.
She's not paying attention at all.
Well, Your Honor,
Is that not weighing at all too? If I'm not paying attention and I fall due to my inattention, can the court not consider that?
the court can consider that, Your Honor, but that is not an issue of whether it's open and obvious. That would go to an issue of comparative negligence, which in this particular case would be a jury question. Was she so distracted that she didn't see this? She's saying that she was looking and she was looking at her grandson, who is a very short individual who was just in front of her. And so she was looking in the general area of where this was, and she still didn't see it. And in her testimony was because it was uniform in color, not because she wasn't paying attention. There is no evidence or no one came forward to say this woman was so distracted by what she was doing that she just fell into a very open and obvious trench. There were no beachgoers that came forward and said, hey, this is all her fault. There is no testimony like that in the record, Your Honor, for the court to have disregarded Mrs. Perez's testimony on that issue. And so,
You're at the 3-minute mark, but as I said, you all were professional enough to say you don't need 40 minutes. So I just wanted to give you that, and if there's something you haven't covered, you may cover, and otherwise, I think we have heard what you need to say.
okay. Thank you, Your Honor. Introduce yourself as you know.
Yes, sure.
Good morning, Your Honor. My name is Samantha Epstein. I am here on behalf of Siesta Beach House and Progressive Community Management.
Good morning, Danny Wanger on behalf of Carlin Strauss and Sarasota. Serving Racing Club.
Do you want to split your time? How would you like to do it? Because I know the arguments are pretty darn similar. You're welcome to both take turns. I just want to make sure we're sort of on track.
I was gonna let Ms. Epstein take the bulk of the time, and if I felt I had anything to add, I'll come up at that.
Why don't we do that, and I'll ask you if you have anything you want to add after she is concluded.
I appreciate that. Thank you.
Thank you. So, Your Honors, in this case, the court correctly granted summary judgment for all of the defendants in this case because the court reviewed the evidence, did not weigh the evidence, and correctly determined that there is no genuine issue of material fact and the conditions at this beach are not dangerous as a matter of law. And I appreciate the court acknowledging that there is no proof that Ms. Perez was ever an invitee of Siesta Beach House and Progressive Community Management. We're not conceding that, of course, but we do acknowledge that the trial court assumed that the Perez's were invitees solely for the purpose of conducting the analysis of whether this outfall was open and obvious and whether it was not dangerous as a matter of law. And nobody is.
But as far as maintenance of it, both parties would potentially be responsible if there was a failure to properly maintain.
If there was a failure to properly maintain, yes, Your Honor. However, there is no evidence that this outfall was improperly maintained or that there was ever any failure of maintenance. Nobody is saying that the plaintiff could distinguish the colors of the sand. The issue, as Judge Morris correctly pointed out from Brookie, is that she should have. Ms. Perez and her family went to Sarasota Surf. They checked in. They spent a significant amount of time on the beach playing until Ms. Perez was walking with her grandson. And it should be noted that her own testimony is unclear as to exactly the mechanism that caused her fall. She testified both that she was watching her grandson and tripped, And she also testified that she was stationary and the sand gave way beneath her feet. But one of the most important things is that she admitted that she is familiar that sand is generally uneven, beaches are uneven. She is familiar with the fact that sand is soft ground that shifts beneath your feet. In other words, somebody can be standing on any portion of the beach and the sand can shift. She acknowledged that that's the case. What there is none of, there is no evidence that in making the outflow or the outfall, that Southern Grade did anything to compromise the sand and make it more or less likely to shift beneath her feet than any other portion of the beach. There's no expert testimony. Ms. Perez herself did not even say the sand felt softer underneath my feet when I walked over this outfall. There's none of that. The only things that Ms. Perez has to rely on to say that all of the defendants, all the appellees in this case were the cause of her fall is the fall itself and the fact that she subjectively could not distinguish between the colors of the sand.
How about the fact that most beaches don't have a ditch like this?
Whether most beaches have a ditch like this is completely irrelevant.
What objectively, what are folks to expect when they go to the beach and expect to have a ditch, same color?
Your Honor, the people who go to the beach should be and generally are familiar with the fact that the sand could be in different conditions for each step that they take. It could be at a different level for each step that they take based on other people walking on the beach, based on the wind, based on water. There is also evidence in the record that these outfalls would exist without Southern Grade coming in and maintaining them the way that they do. But Southern Grade testified that the way the water flows from the properties down to the Gulf means that if these outfalls were not maintained by Southern Grade to be straight lines, they would waver in an S shape, in a serpentine shape down the beach, potentially creating a more problematic condition where it's not an even line that goes directly from the properties down to the beach. All we have is that the plaintiff was there, Ms. Perez was there on the beach, had a significant amount of time to observe her surroundings and simply failed to do so. She wants to argue that the trial court weighed the evidence, but the trial court didn't weigh the evidence. The problem that Ms. Perez has is that the evidence does not reach the level of what she has to prove. In order to prove that there was negligence, she has to prove that there was a duty owed. In order to prove that there was a duty owed, she has to prove that this condition was dangerous. Brookie makes very clear that it's an objective standard, and it also makes it very clear that the court has to look at the objective standard for the area or for the conditions that are typical of where the alleged injury occurred. In this case, it occurred on Siesta Key Beach, which has approximately 26 outfalls, according to Southern Grade. Those outfalls have been there for decades. It is not a natural condition, but it is a necessary condition of this beach. Just as in Brookie, where there was a pallet, typically there are pallets that get delivered to stores. And even though that pallet was only there temporarily, it is something that people should be aware that they must be on the lookout for. These folks decided to go to this particular beach.
I'm thinking about that. She had never been to this beach before. Is that correct? Do we know?
Do we know? I don't think she had been there. No, I don't believe she had been there, Your Honor.
She was on vacation. She got there that day.
Yes.
It was a couple hours later that she had the fall.
Yes.
And so I'm not certain that people coming for vacation on Siesta Beach or any beach would necessarily know that for the past 20 plus years, there are these outfalls. So I'm not quite sure that that's an argument that wins the day for you.
I think what it does show is that those outfalls have been in existence for decades and nobody else has fallen, right? And even in Gorin versus City of Augustine, the court acknowledged that there's no way to make any property so safe that nobody could get hurt.
So the point though would be that your client was not on notice that there was a problem because no one had ever fallen before.
Correct. That's part of our argument, Your Honor. But in Gorin versus City of Augustine, the court even acknowledged in that case, there was evidence that other people had fallen before off the curb. And the court still found that the curb was not dangerous as a matter of law because the conditions at that property were so common and so innocuous that it could not be dangerous as a matter of law, even though there was evidence from the tram drivers that other people had gotten hurt in exactly the same fashion at exactly the same spot. In this case, there's no evidence that anyone has ever gotten hurt before. There's no evidence that the sand in the outfall acted any differently than the sand at any other part in the beach. There's nothing to say that this was improperly maintained. There was no debris. There's no testimony that it was a sharp drop off or was a sharp curve. There was nothing to show any breach of any duty, or there's nothing to show that there was even a dangerous condition. Yeah, I think the court was proper in looking at the photographs and saying not that Ms. Perez did see this, but that she should have. And just quickly to distinguish the Schramm case, because I know that the Perez's rely on that pretty heavily with their notice of filing. In that case, the ground that the plaintiff walked on, the grass, acted differently than grass is expected to act because of the weakening of the soil underneath it. There's nothing to indicate in this case that there was anything different about the sand or that it acted any differently. Of course, we don't have a case that says an outflow is not a dangerous condition as a matter of law. But looking at all of the cases that we cited in our brief, collectively, they show that in order to overcome a motion for summary judgment, the Perez's in this case had to come forth with some sort of evidence to show that the sand in the outfall acted differently than other sand in order to give rise to the duties. They had to show something to show, such as, the pothole cases or the cracked sidewalk cases, something to give rise to anything that might allow a jury to potentially infer that there was deferred or a failure to maintain this outfall. The only evidence we have is that it's maintained regularly and that nobody's ever tripped on it in the decades that it's existed. Ms. Perez's subjective inability to see.
I think we got that point.
Thank you.
You're certainly welcome to continue.
Of course.
If that's something you want to share.
Of course, but her subjective inability was never disregarded by the trial court. It just simply isn't enough to overcome summary judgment in this case. So if the court has no more questions, we will rest on our brief, and I don't know if Sarasota Surf has anything to add.
I think co-counsel.
I think you were trying to say.
I think co-counsel.
This is a strange, the worldwide audience. Anything.
Counsel did an excellent job of making the same arguments we would make unless the court has specific questions as to Sarasota Surf and Riding Club.
Very nice. Thank you so much.
Thank you, Your Honors. Wanted to go back for just a moment because we are talking about whether Mrs. Perez was paying attention. There is no direct evidence that she was not paying attention in this case, and we're on summary judgment. Any inference as to whether she was paying attention or not needs to be considered in her favor. It had to be considered that she was paying attention and not able to see the ditch in this case. Now,
am I recalling correctly that basically her testimony was, I didn't see it because the sand all looked the same. And that is, as far as I can remember, the scope of the evidence that was offered by the plaintiff.
that is correct, Your Honor. As to the condition of what the sand looked like, one of the, I believe it was the president of the board for Siesta also indicated that it looks just like the general area around it. But that was the evidence from Mrs. Perez, was her saying that she was unable to see it because it was all the same color. And Your Honor has, Judge Morris, you've asked a couple of times regarding the notice issue. I would like to point out in the record, both Sutton's corporate representative has indicated that if anyone is walking down the beach and there's a hole on the beach, it may be dangerous. Clifford, who is the person for Southern Grade, testified that he was paid to fill in holes on the beach, other holes. And so the idea that this ditch, they wouldn't have known that it could be a dangerous condition if somebody was, wasn't able to see it, is clearly not supported by the record and those particular sites. The argument that was made in terms of, yes, there are, differences in elevation all throughout sand. That's not what we're talking about here. We're talking about a man-made ditch that was 2.5 to 3 feet deep on the day that Mrs. Perez fell into it. And I would also like to distinguish the case of Brookie, which counsel argued is applicable here. But in the case of Brookie, he saw the pellet 3 times. And it was on the 4th time going by it that he injured himself. And the court said it wasn't enough. That was open and obvious to you. And if there are not any other further questions, Your Honor, I don't know that I need to use the remaining few minutes of my rebuttal time. It is our request that this court reverse the trial court's grant of summary judgment. Thank you.
Thank you.
Thank you very much, and for those of you from South Florida, thank you for coming to visit us.
Thank you very much, Your Honor.
Thanks for having us, Your Honors.
The final case on today's docket is Jakowska versus Appellate.